4:12 a.m. Olympic National Forest, Washington State. January 9th, 2026. 16 operators from the United States Marshals Service Special Operations Group moved single file through second-growth Douglas fir in near-zero visibility. Thermal optics, suppressed radio, 400 meters uphill, a cinder block structure built in 1962, decommissioned in 2014, padlocked, fenced, marked on every federal property map as permanently closed. A woman named Larisa Beane had been inside for 67 days. The breach team cleared the main floor in 40 seconds. The basement door was reinforced steel. It came open on the fourth strike from a hydraulic spreader. Inside a locked room behind a plywood partition on a folding cot, a 38-year-old forensic accountant from Tacoma, Washington. Alive, 21 pounds lighter than her driver's license photo. Responding to verbal commands. Both men in the structure were taken without resistance. The building was cleared and secured in under 2 minutes. A perimeter element held position on the access road and the eastern tree line throughout the operation, maintaining containment in case of additional occupants or an approach from the logging route. A forward communications relay positioned between the target structure and staging area kept the Tactical Operations Center in Tacoma in constant contact through the entire breach. Federal arrest warrants came down at 4:17 a.m. By 4:47, the prosecutor handling the Spokane commercial fraud case had been notified by Secure Line. Trial, originally scheduled for November of 2025 and postponed after Beane's disappearance, was rescheduled. The United States Marshals Service issued no public statement that day. No press conference. No confirmation to the regional media that had been covering the disappearance since early November. Official silence for 9 weeks. What became public later, piece by piece through court filings and FCC records made available after the arrests, was this. The investigation had stalled. 3 federal agencies, an interagency task force, 814 tips, 67 days with nothing actionable, and then a retired hobbyist in Sequim, Washington filed a routine interference complaint with the Federal Communications Commission. That complaint, cross-referenced by one field engineer against a quietly circulated interagency bulletin, pointed to a logging road in the Olympic interior that no one in the task force had thought to check. One retired electrician with a notebook and a shortwave rig. Here is what happened. Larisa Beane had spent the previous 14 months working on a complex federal fraud case from the Eastern District of Washington. She was not a special agent. She was a consulting forensic accountant hired by the United States Attorney's Office to trace the money through what the initial indictment described as a coordinated scheme to defraud federally backed commercial lending programs. In plain terms, a group of Spokane area property developers and commercial loan brokers had inflated the appraised value of 26 commercial properties, obtained federally backed loans against those inflated figures, pocketed the difference, then allowed the properties to default. The aggregate federal exposure was $42.3 million. The documentation trail ran through 6 shell companies, 3 external accountants, and 2 law firms. Standard automated compliance systems had not flagged a single transaction. Each individual transfer was too small, too irregular, and spread over too long a period to match fraud detection patterns. Beane found the thread that automated systems missed. 637 wire transfers over 27 months, moving between a property management company in Cheney, Washington, and a payments processor in Reno, Nevada, that had no documented commercial relationship to any Spokane real estate transaction. Amounts varied from $800 to $4,600 with no discernible pattern. Total moved, $1.4 million. Once she flagged it and traced it backward, it connected all 26 properties. By October of 2025, a grand jury had indicted 4 defendants, 2 had accepted plea agreements. 2 had not. Garrett Aldrin, 51, a commercial real estate developer with a clean prior record and a law firm on retainer, and Raymond Kessler, 63, a retired commercial loan officer who had personally processed 11 of the 26 fraudulent applications from inside a regional bank during the years the scheme ran. Both men were out on bond, awaiting trial. Those 14 months of work had consumed most of Beane's professional calendar. She had declined 2 other consulting contracts during the same period to maintain continuity on the Spokane case. Her personal files, recovered from the Port Angeles safehouse after her disappearance, contained 3 separate backup copies of her working analysis. One stored on a federal evidence server, one on an encrypted drive she kept in a fireproof case at her home office in Tacoma, and one in printed form, annotated in pencil in a binder she had prepared specifically for the prosecutor. Whatever happened to Beane, the evidence would survive. She had planned for that possibility before she agreed to testify. Beane's testimony was the spine of the federal case. She was the only person who could put the wire transfer pattern in front of a jury in a form a jury could follow and understand. The United States Marshals Service relocated her to an interim safehouse in Port Angeles, Washington, 4 days before she disappeared. The address was not on any prior protective custody roster. It had been selected specifically because it had never been used in that district. The number of personnel with knowledge of the location? Fewer than 12. On the morning of October 28, 2025, a deputy drove to the Port Angeles safehouse to confirm transport for the 3rd pre-trial briefing. The front door was unlocked. The service-issued tracking phone the unit marshals used to monitor witnesses in transit was face down on the bed. Battery still active. On the kitchen counter, a mug of coffee still warm. No forced entry, no damage to locks or windows, no neighbor disturbances. Larisa Beane was gone. The response was immediate. Field teams from the Marshals Service reached Port Angeles within the hour. Forensic technicians processed the safehouse over the following 48 hours, cataloging all contents and documenting the condition of every entry point. The service-issued tracking phone and Beane's personal phone, which had been disabled before it could be pinged, evidence of deliberate counter-surveillance knowledge, were transferred to the FBI Seattle Field Forensic Lab. The finding confirmed what investigators suspected from the moment they saw the undisturbed kitchen. Whoever conducted this abduction had direct awareness of how federal witness tracking protocols functioned. Surveillance footage from a gas station 2 blocks from the safehouse captured a silver Chevrolet Tahoe parked at the curb for 11 minutes beginning at 8:49 a.m., 44 minutes before the deputy's arrival. The plates came back to a rental agency in Bellevue. The rental agreement used a false identity. The credit card that secured it, a prepaid card purchased with cash at a Portland, Oregon pharmacy 12 days earlier. Whoever planned this had been working on it for at least 2 weeks. The investigation ran on 2 tracks simultaneously. First, how had the safehouse location leaked? Second, where was Beane being held? For 11 days, the internal inquiry into the potential compromise of the Marshal Service consumed more resources than the active search for Beane. The eventual finding, completed 7 weeks later, identified no deliberate insider disclosure. The most probable source, a routine case management log entry, required by system protocol, that had been accessible to a member of the defense legal team who subsequently resigned from the firm 2 weeks before Beane's disappearance. That finding came far too late to help anyone in October. The Olympic Peninsula presented a search problem with no clean technical solution. Over 1,000 square miles of federally protected wilderness, national forest, and national park. Cell infrastructure largely confined to coastal corridors. Road access controlled at multiple National Park Service and Forest Service trailheads, most gated from November through April. The standard fugitive recovery toolkit, license plate readers, cell tower analysis, financial monitoring, informant networks, returned almost nothing useful. The Silver Tahoe was found abandoned in a Sequim parking lot the afternoon of October 28th. The trail ended there. The task force went wide. Interagency BOLO circulars to Washington State Patrol, Olympic National Forest Service Rangers, National Park Service law enforcement, and every county sheriff's office across the peninsula region. 814 tips logged and processed over the following 3 weeks. None produced an actionable location lead. What the task force could not know was that the 2 men holding Beane were not moving. They had no reason to. The plan, as it would later emerge from statements taken after the arrest, was to hold Beane in a fixed location until the 60-day window before trial expired, at which point their understanding went, the federal indictment would lapse. That logic had a fundamental flaw. Federal prosecutors rescheduled the trial on day 3 of Beane's disappearance. The countdown Aldrin and Kessler believed they were waiting on had already been reset. The plan was waiting for a deadline that no longer existed. I went through the court record and agency communications unsealed after the arrests, and one detail kept standing out. The 2 men hired to hold Beane were paid a flat fee, $45,000, transferred in 3 installments through a mobile payment platform using accounts registered to a landscaping company in Yakima. They had no exit strategy, no contingency. Their communication channel to the defendants was a single burner phone with 1 saved contact. The sophistication of the abduction, the counter-surveillance timing, the false identity rental, the pre-selected remote location, is completely at odds with how little planning went into what came after. The people who commissioned this were operating a $42 million fraud network. They hired captors with no endgame. The task force processed its 814th tip on November 20th. The official posture. Without a directional lead, the search was transitioning to passive monitoring. Aerial thermal surveillance over that terrain required a target quadrant to be cost-effective. There was no quadrant. 49 days into Beane's captivity, something entered the record that had nothing to do with the Marshals, the task force, or the investigation at all. If this kind of case is what you're here for, federal operations where the break comes from completely outside the system, hit the like button now. It helps more than most people realize. Walter Brink was 64 years old and had held an FCC amateur radio license since 1982. He lived in Sequim, Washington, a town of roughly 8,000 on the northern edge of the Olympic Peninsula, about 40 miles east of Port Angeles. His station operated primarily in the high-frequency shortwave bands, and he kept meticulous logs of propagation conditions, signal anomalies, and atmospheric variables across each session. Not a professional pursuit, a discipline maintained across 4 decades. On December 16, 2025, Brink was running a routine propagation survey on the 40-meter band, 7 megahertz, when his directional antenna registered an unusual contact. A low-power carrier wave transmitting Morse code digits at irregular intervals. It lasted about 11 minutes before it cut out. The bearing south-southwest of Sequim into the Olympic National Forest interior, in an area where the FCC amateur license database showed no registered operator. Brink noted the time, the frequency, the approximate bearing, and the Morse content in his log. He could not associate the digit string with any known amateur operating procedure. The following morning, he filed an FCC interference report. Standard form, standard routing. The FCC receives dozens of such reports each week. Average processing time for routine complaints like this, 12 to 15 days. The FCC Pacific Regional Field Office was operating with reduced staffing in December. Brink's complaint, filed December 17th, entered the standard queue. The field engineer assigned to Pacific Northwest interference cases, David Calloway, did not open the file until January 6, 2026. 9 working days. Calloway's first step was standard procedure. Cross-reference the signal bearing against registered amateur licenses, registered commercial operations, and known federal or military installations in the region. No match on any category. His second step was not in any procedure manual. He queried an interagency information sharing system the FCC used primarily for FAA and NOAA frequency coordination. That system held a flagged note, a Marshals Service BOLO active since November 4, 2025, requesting any interagency reports of anomalous activity in the Olympic Peninsula interior in connection with a missing federal witness. Calloway printed a topographic map of the Olympic interior along the azimuth Brink had logged. He identified the largest enclosed structure within the probable signal range, a decommissioned Forest Service ranger station built in 1962, removed from the active property roster in 2014. Access road off a Forest Service maintenance route, gated, no recent inspection record. He drove the access road himself on the afternoon of January 7th. He did not pass the gate. He noticed the gate's padlock was newer, a different manufacturer with no weathering from years outside. He photographed tire tracks in the mud on both sides of the gate, 2 tread patterns, one consistent with a light truck. Then he called the Marshals Service field office in Tacoma from the road at 2:56 p.m. Here's what this case tells us about how interagency systems actually function versus how they are designed to. The BOLO worked exactly as intended. The FCC cross-reference produced the connection it was built to produce. The information was in the system. But the signal that found Larisa Beane traveled through a retired hobbyist's 43-year logbook, a 9-day processing queue, and one field engineer's decision to ask one more question than his job description required. Not a satellite, not a fusion center, not a predictive algorithm. A man who paid attention to his antenna for 4 decades, and another man who drove a road himself rather than wait for someone else to. The strangest part of this case isn't the amateur radio element. It's what the radio was actually transmitting. Court records and forensic analysis of the ranger station completed after the arrest confirmed this. The carrier Brink detected was not equipment interference or an accidental emission. Someone inside that building had constructed a makeshift low-power oscillator. Forensic examiners found evidence that Beane had accessed a vehicle battery stored in an attached utility bay and identified usable electrical components in a maintenance cabinet. The digit string she was transmitting was a repeating sequence. Her 6-digit case reference number from the fraud file she had been working for 14 months. She had memorized it. She had no formal radio training. She had enough knowledge of direct current circuitry from 14 months of auditing electrical contractors' billing to rig something. She transmitted for 11 minutes before the battery voltage dropped below the oscillator's operational threshold. She had no way of knowing whether anyone was listening. She was on day 49. Calloway opened the interference report on day 65. 16 days separated the transmission from the moment anyone connected it to the right investigation. Calloway's call reached the Marshals Tactical Operations Center at 2:56 p.m. on January 7th. The SOG deployment order was signed at 5:32 p.m. 16 operators. Tactical transport, a field medical team on standby at the staging area. The operation was on. What no one at the staging point could confirm was whether anyone inside the structure was still alive. The staging area, a Forest Service access point 7 miles from the target structure. Weather on the evening of January 8th. Overcast, 31 degrees Fahrenheit. Intermittent rain. Satellite thermal imaging conducted that afternoon showed 2 heat signatures consistent with a portable generator on the structure's west side, 2 human-sized sources on the main floor, and a third signature, weaker and lower in the building, in the subterranean section. The third signature was faint, consistent with a living person barely alive. The operational decision, wait for daylight and risk detection if the captors monitored traffic on the access road, or move at 0400 through 400 meters of uphill terrain in minimal visibility against a potentially fortified interior. The SOG commander chose to move at 0400. Here is a position that will draw disagreement. Garrett Aldrin and Raymond Kessler should not have been on standard bail while Larisa Beane was an active material witness in a live federal prosecution. The federal system permits bond for nonviolent defendants without prior records. That is legally correct and procedurally standard. But here's the gap. 2 co-defendants with the financial sophistication to engineer a $42 million fraud operation, both walking around on unenhanced bond while the prosecution's sole material witness needed Marshals protection. That is a gap this case has to stand for now. The federal court had every legal mechanism available to impose electronic monitoring capable of flagging the mobile payment transfers used to commission the abduction. It didn't. Beane spent 67 days in a basement because the standard bail calculation assumed defendants without prior records do not commission kidnappings. These ones did. What do you think? When a federal prosecution rests on a single material witness, should the bail calculation change for co-defendants regardless of prior record? Leave your answer in the comments. It is not a simple question, and the Aldrin-Kessler case is now part of that legal argument. The breach team covered 400 meters of uphill terrain in 6 minutes under thermal imaging. 2 stationary heat sources remained on the main floor throughout the approach. The main entry door opened without resistance on the first strike. The 2 occupants, Travis Elway, 34 of Yakima, and Marcus Dorn, 41 of Kennewick, were on the main floor. Both were carrying prepaid mobile phones. One device had a single active contact, consistent with the burner number subsequently identified as linked to Kessler. The other was registered to the Yakima Landscaping Company identity used for the payment transfers. Elway moved toward a rear window as the team entered. He was on the floor and restrained within 3 seconds. Dorn did not resist. Forensic extraction of both phones was completed at the Tacoma field office within 24 hours of the arrest. Call records showed that contact from the defendants had stopped entirely on November 14th, 36 days into the captivity. After that date, Elway and Dorn had been maintaining the situation with no further communication from either Aldrin or Kessler. No updates. No instruction on when to release the witness or how to exit the situation. The defendants had commissioned the abduction, established the location, and then gone silent. The captors were waiting on a call that was never coming. The basement access door, reinforced steel frame, welded over the original hinges after the station's decommissioning. The hydraulic spreader took 47 seconds. Beyond the door, a room 8 feet by 10 feet. Concrete floor, a portable space heater powered off, 2 water containers, 3 metal buckets, a folding cot with 2 sleeping bags laid over it. On the cot, Larisa Beane, conscious. She answered the first verbal command with her full name and date of birth. The field medical report notes her first question, asked in a voice the attending medic described as controlled and deliberate, was whether the trial date had been preserved. She was told yes. There is one line in the emergency services handover report that sticks. Under the section labeled Patient Communication at Scene, the attending medic wrote, "Subject asked immediately whether trial date had been preserved. Required verbal confirmation before consenting to transport." The medic also noted that Beane had maintained a rudimentary daily record during her captivity. 67 marks scratched in pencil on the concrete wall behind the cot. She had tracked the days from the first morning she woke up in that room. She had been in that room for 67 days. The first thing she asked about was the trial. She was transported by helicopter to Olympic Medical Center in Port Angeles, arriving at 5:21 a.m. The full medical intake took 9 hours. Field testing at the scene confirmed the presence of benzodiazepine compounds consistent with counterfeit alprazolam. She had been administered counterfeit sedatives on a schedule the captors controlled. The exact dosage history was a matter the medical team reconstructed after the fact. The rescue was complete. The captors were in federal custody. But the case had just opened a second front. DEA laboratory analysis of the counterfeit alprazolam, completed the week following the rescue, traced the supply chain to a manufacturing operation in California's San Joaquin Valley, producing counterfeit benzodiazepines for distribution across 3 western states. That operation became the focus of a joint DEA and FDA Office of Criminal Investigations case. At minimum, 14 identified end users across California, Oregon, and Washington had received product from the same supply network. The Aldrin Kessler abduction, in reaching for a sedative supply outside any legitimate pharmaceutical channel, had intersected with an enforcement priority that had been running completely separately. One kidnapping had exposed a drug manufacturing network. The drug network was bigger. One detail we could not get confirmation on before this recording: whether Callaway's cross-reference of the interagency BOLO system required elevated clearance, or whether that database was accessible to standard FCC field staff. If you work in federal field operations or FCC compliance and you have context on how that access tier functions, drop it in the comments. We read everyone. Garrett Aldrin and Raymond Kessler were remanded into federal custody on the morning of January 9th, bond revoked. Both entered not guilty pleas to charges of witness tampering, obstruction of justice, and conspiracy to commit kidnapping. The original commercial fraud indictment was reinstated and expanded with additional counts. As of the time of this recording, no trial date had been publicly set. Travis Elway entered a cooperation agreement. Marcus Dorn did not. The $45,000 paid to the captors had been spent. No recovery was possible. Dorn's federal kidnapping charge under applicable enhancement statutes carries a potential sentence of life imprisonment. Elway's cooperation will factor into his sentencing range. Neither outcome had been determined in the most recent public filing. The counterfeit alprazolam supply network remained partially active according to unsealed court documents. 7 of the 14 identified end users had been contacted by federal investigators. The remaining 7 had not been located. Subscribe so you don't miss the update when the Aldrin Kessler trial schedule is announced. The defense team has already signaled a challenge to the admissibility of Beane's testimony on grounds related to the conditions of her captivity during the period it was constructed. That argument is going to raise questions about the federal witness protection statute that have not been litigated at this level before. Continuation Arrow Walter Brink, the Sequim radio operator, was interviewed by federal investigators in January and received a letter of commendation from the United States Attorney's Office for the Western District of Washington. He runs his propagation surveys every morning at 7 a.m. Larisa Beane testified at the rescheduled trial. She had been moved from her safe house precisely so that she could not. The people who moved her misunderstood one thing about federal evidence. A witness can be silenced. The wire transfer logs, the shell company filings, the 637 transactions she had traced across 27 months. Those could not. Evidence does not require a witness to exist. It requires someone to present it. Beane presented it. The counterfeit drug network that kept her sedated for 67 days had supplied other buyers before federal investigators reached it. What those buyers used it for is a matter still